This is one of those courtroom moments where patience runs out and consequences hit hard. A defendant with multiple chances, repeated bond violations, and a growing list of charges now stands in front of a judge who's clearly seen this pattern before. What started as a domestic dispute has escalated into something much more serious, involving allegations of violence, evasion, and ignoring court orders. The real question is, how many chances is too many? And when does the system decide enough is enough? Stay with us, because this hearing takes a sharp turn when the judge lays everything out. And trust me, you won't want to miss what happens next.
He has two cases, an assault family violence that was a prior bond forfeiture, and a failure to ID. I was appointed this morning on those cases and we have filed bail orders.
Okay.
On the we're requesting PR bonds, sir. On the old assault family violence, he did let me know, he was in communication with his attorney and his appearances were being waived over an ERD court. I do show a reset from July 1st saying he doesn't need to appear and setting it for July 3rd where he does need to appear and his signatures are not on it. And he said he did not know. But
He picked up a felony violation of a bond condition.
that's correct, Your Honor. That was filed as a 2B warrant.
I don't know anything about the cases and I haven't spoken to him in a very long time. Does he speak English?
He does, yes, sir.
Great. I'm going to have them. Is he bringing him up? He has not made bond on the felony case, so.
That's correct.
Good morning, Mr. Mendoza.
Morning, sir.
Sir, you're charged with 2 cases with us. You were charged with assault of a family member. You're now also charged with failure to identify oneself to a peace officer while being a fugitive from justice. That allegation kicks it up to a Class A, so you're also facing a year in jail and or a $4,000 fine. This case the assault is a year old. I have no idea what is going on with it, so I'm going to have you refresh my memory real quick. What happened, please?
On the AFM?
Please. On all 3.
So on the AFM, which is the original charge, on April 6, 2024, officers spoke with a complainant witness who stated she was involved in a physical altercation with the defendant after the defendant became upset with her over food and struck her several times with a closed fist in the nose and mouth, causing her pain and visible injury. Officer observed the complainant witness to have a swollen bottom lip with a small laceration, and she was holding a bloody towel that she used for her nose. Defendant was identified by his Texas driver's license, and the defendant and the complainant witness have been in a dating relationship for 8 years. So that's the oldest AFM. Do you want me to do the felony?
Yeah.
Okay.
What?
So on the felony, on June 4th, 2024, officer responded to a disturbance call and spoke with the complaining witness. Complaining witness stated the husband threw her on the wall after she called his mom to complain of his behavior. Complaining witness said she had a protective.
Shh. I didn't hear any of it.
Officer, on June 4th, 2024, officer responded to a disturbance call and spoke with the complaining witness. Complaining witness stated that her husband threw her against the wall after she called his mom to complain of his behavior. And then she stated that she had a protective order against the defendant. And then the failed to ID on April 11th, 2025, officer dispatched to an unknown disturbance call for service. Officers arrived on scene, knocked on the door. Officers observed a male come to the door, but quickly move out of the way, not wanting to answer the door.
This is the turning point.
Officers,
and you can hear the shift in the judge's tone immediately. Up until now, this was just another case being reviewed. But the moment repeated violations, skipped appearances, and attempts to avoid law enforcement come into focus, the entire situation changes. From a legal standpoint, PR bonds, also known as personal recognizance bonds, are based on trust. The court is essentially saying, we trust you to come back without paying. But when that trust is broken again and again, the system tightens. And here's the bigger issue. This isn't just about missing court dates. It's about public safety, especially in cases involving alleged family violence. So let me ask you, should the court keep giving chances, or is the judge right
the defendant
to draw
walking out of the
line
door
here?
stating that he was only having a verbal argument with his wife.
So
Officers-
now a new fight and that's what brings the cops to the house?
I believe so. Officer spoke to the female on scene. Officer stated the female was not answering questions due to not wanting to get the defendant in trouble. Officer observed the name and date of birth the defendant provided to officers were not coming through a TCIC search. Officers advised the defendant that if he does not have proper name and date of birth, he'll be charged with failure to identify. The defendant then confessed and provided his real name and date of birth. The defendant stated he did not want to go to jail for a warrant that he had. And then the officer observed that he had a felony and misdemeanor warrant.
The reason I'm trying to, you speak English, right?
Yes, sir.
The reason I'm trying to figure what's going on is because she's asking me to give you a PR bond, but
Yeah.
we've given you bond after bond after bond. You've been in flight status for about nearly a year. And now when the cops come to try to talk to you, you try to evade again. You know what I mean? Are we just going to continue to give you chance after chance? You continue to you just don't give a shice about bond conditions, man. Really? I mean, I get it that he may have not signed it or whatnot, but you can't just be out of sight, out of mind for an entire year and expect good things to happen. I mean, really, we've given you PR bond after PR bond. It would just, at some point, I have to say when, so that we mean business. There's no more revolving doors, Really.
The original AFM, it looks like they did do a written call. The complainant advised that the reason that she had a bloody nose is because she does drugs and was doing cocaine. He did have the PR bond. The VPO was a 2D warrant, so he wasn't given bond and didn't come on that one.
Yeah, but he had a warrant sought for both. Apparently knew about them. So I'm
Well,
not.
it didn't say that he knew about the felony warrant,
Well, I don't know,
Yeah,
but
warrant out.
but you can't make believe that he knew.
I mean, I can, if you want a bond reduction, I'm willing to give you a bond reduction. I'm not going to give you another PR bond, dude. Really, I'm just, no more PR bonds. And you've got these cases out. Just, you can't out of sight, out of mind. And the only reason you're here now is because you got into another damn argument. So, Mr. Mendoza, I am now issuing another protective order on this case. And I want you to understand that the Texas Constitution does not allow me, but in extremely limited circumstances, to have a hearing to hold someone at zero bond. This is now one of those cases. If you continue to violate protective orders, we can have a hearing to hold you at no bond. Do you understand? I don't want you to have contact with this person. No means no. Doesn't mean, please, baby, get me out of jail. Every phone call is recorded. Take note when you're making phone calls. Every phone call is recorded. Do you understand?
Yes, sir.
I'm not asking for much. All I want are my streets to be safe. And if you can,
Yes, sir.
just don't have any contact, don't have any weapons, and that's it.
Sir.
If you want a bond reduction, I'm happy to give it to you, but I'm not going to just continue to give homeboy PR bond after PR bond after PR bond. Just not,
Would the court be willing to reduce the bonds to $1,000?
I'll cut it in half. So on the assault, 2,500. I'm going to leave the failure to ID as is, but I'm telling you now, I don't know if you're going to get out, but if you do, there is a residential restriction. You cannot go within 200 feet of where she lives or where she works. Do you understand?
Yes, sir.
No alcohol, no illegal drugs. You will be randomly tested. No contact and no weapons. Do you mind? All I need you to do is file the MOA because we'll have him, pre-trial is going to, make sure that you're in compliance. All right, Mr. Mendoza. So what we'll do is the felony case is set for June. So what we'll do is, I don't like to set the people for more than 30 days so you just don't get forgotten about. We can set you for 30 days, come back, and then, go from there. Okay? All right. Yes, ma'am. Thanks.
This case is a textbook example of how the justice system balances second chances with accountability. The defendant was given multiple opportunities through PR bonds, but repeated failures to comply, combined with new allegations and violations, ultimately led the judge to take a firmer stance. Instead of another release based on trust, the court imposed stricter financial conditions, a protective order, and clear behavioral restrictions. No contact, no weapons, and monitored compliance. These decisions aren't just procedural, they're meant to protect individuals and prevent escalation. The takeaway? Ignoring court conditions doesn't just delay consequences, it makes them worse. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.